Good morning. Welcome, everyone. I'm going to give folks a couple of minutes to get into the space, and then we'll get started. Okay. Good morning, everyone. My name is Brittany Galati. My pronouns are she, her, and I serve as the Public Policy Coordinator for the New York State Coalition Against Domestic Violence. I would like to welcome everyone to NYSCADV's 2023 End of Legislative Session webinar. Before we start the presentation, I'd like to go over some housekeeping items. For any questions or comments that may come up during the presentation, please use the chat box. We will do our best to answer questions as they come in, but there will also be ample time for questions at the end of today's presentation. Within the chat box, you can choose to share your questions or comment with everyone or with myself by changing the to line above your chat text box. Time permitting, live questions may be asked during the Q&A section. Please use the raise your hand feature to indicate you would like to ask a question at that time. Today, we are providing live captioning. To enable closed captioning, click on the closed caption button or the more menu and select show subtitle for closed captions to appear in Zoom. We are recording today's presentation. A link to the recording as well as materials referenced and a copy of the presentation will be made available very soon after this recording is released. And now I would like to introduce NYSCADV's Director of Public Policy and Advocacy, Joan Gerhardt.
Thank you, Brittany, and good morning, everyone. Welcome to this year's version of NYSCADV's 2023 Legislative Session Review webinar. First, I want to give my thanks to Jennifer Clark and Brittany Galati, my colleagues at NYSCADV, for helping to facilitate today's webinar. We have a lot to review this session. We left 90 minutes for this discussion. I actually think we're going to take a large portion of that today. We are, as Brittany said, going to save time at the end for questions, but certainly as we go through the presentation, please don't hesitate to put questions in the chat, and we'll try to address them when we're on a particular bill or item that we're reviewing at that time. So what we do hope to cover today is first a review of this year's state budget. It would be the fiscal year 23-24 budget, and that was approved on May 2nd of this year. And we're going to review both some appropriations that are important to domestic violence survivors and service providers, as well as Article 7 policy initiatives. And then we're going to move on to taking a look at some important legislation that moved through the chambers this year. We're going to start with a look at those bills that have already been signed into law by Governor Hochul, and then reviewing bills that pass both chambers, but Governor Hochul has not yet acted upon. And then we're going to take a look, you're going to see our predictions for what's next in 2024. And as I said, there will be time at the end for questions. And I do want to reiterate for those who joined maybe a few seconds late that this webinar is being recorded, and the slides and the recording will be made available to all registrants. So let's go ahead and get started. The way I chose to talk about this year's budget appropriations is by looking at the funding that's been maintained from last year's budget to this year's. Then we're going to talk about the appropriations that increased, so more funding for certain items. And then we'll look at some new funding appropriations that are in this budget that didn't appear in the past. So I think I would be remiss if I didn't start our funding discussion by talking about VOCA. For anyone who's on the call who has obtained an OVS VOCA subgrant, you probably are aware that the federal VOCA dollars coming into New York State has been declining quite significantly. In fact, in the past 5 years, from 2018 to 2023, New York State's VOCA grant has declined 121.6 million. It's now about $77 million. Obviously, the state can't do as much in terms of programming and provision of services when there are such declines in our federal grant. So NYSCADV, along with many other statewide coalitions and service providers, have been advocating, working with the state to come up with a multi-year solution to this shortfall in the VOCA funding. This year's budget included a $14.4 million transfer of state revenues to OVS to make up some of this shortfall. And we saw the first installation of a $14.4 million transfer in last year's budget. So with this year's $14.4 million, that's a total of $28.8 million. And we do anticipate seeing this $14.4 million in next year's 2024 budget as well. But this isn't nearly enough to cover the cuts to New York State's victim service providers. We know that some legacy providers, about 90 providers, have been cut pretty substantially for a total of $11.7 million each year of the existing 3-year contracts. That amounts to $35 million over those 3 years. And we're now hearing OVS inform grantees that it's not sure it can satisfy the 3rd year of those existing contracts. So much more needs to happen from the state in order to ensure the sustainability and accessibility of victim services across the state. So we can certainly take more time to review that at the end of the discussion, but I think that gives you a good framework for understanding where we are with the budget with respect to VOCA. This year's budget set aside the same amount of funding for the domestic violence shelter reimbursement. The state uses TANF and Title 20 funding for that purpose. And we also saw the amount of TANF funding that the state earmarks for non-residential domestic violence services maintained at 3.2 million. And this is something that we've been advocating to increase. We're hoping to double that to 6 million, but unfortunately that didn't happen in this year's budget. OCFS continues to get $5 million allotted per year to study how New York State funds domestic violence services, particularly through the per diem reimbursement model. At this point, looking at how much funding is contained within the reappropriations of the budget, OCFS has a nice pot of money to conduct this pilot, about 20 million. And we also saw the 2.5 million or 2.4 million earmarked for OTDA for their human trafficking program. Last year, you might remember that the Enough is Enough funding that had been administered by the Department of Health was transferred over to OPDV for administration. And this year's budget maintained that $4.5 million at OPDV. And we saw the same line item appropriations for DCJS, 7.2 million for community safety and restorative justice programs that include support for domestic violence and sexual assault survivors, 4.2 million for civil and criminal legal services for domestic violence victims and others, and 6.5 million for rape crisis services. So now looking at some of the funding that increased, New York State is setting aside funding for its new sexual offense evidence storage facility in Washington County. That funding was bumped slightly to 1.5 million. We saw a doubling of the amount of funding available for pretrial services from 10 million to 20 million. And we also saw a significant pot of funding set aside for the state's ERAP, the Emergency Rental Assistance Program, and that's administered by OTDA. So now looking at some new funding, You may have heard that OPDV has a new $5 million line item in the budget for grants to government entities and nonprofits to provide financial assistance to domestic violence victims. So this is pretty exciting, and we're waiting to hear more information from OPDV on how it intends to distribute that funding to nonprofits and government entities. There's a new $10 million earmark to DCJS for it to investigate and enforce extreme risk protection orders. A new $50 million earmark to OTDA for legal services and representation for eviction cases, and $227 million for the state's gun violence prevention efforts. And this is broken down. There's some money going to the Office for Gun Violence Prevention, some funding going to communities that experience gun violence in the aftermath. There's money going to local law enforcement for their gun violence prevention efforts. So a lot of funding there for gun violence prevention. So this concludes what I wanted to review in terms of the appropriations aspect of the budget. There's far more funding in the budget, some of which does touch upon domestic violence survivors, but I think these are the most important appropriations for us to review. So now let's move on to the Article 7 measures. So Article 7 measures are policy initiatives that the governor places in the executive budget, which is issued in January, and it's her opportunity to propose legislation. So unlike a senator or assembly member who can draft a bill if they have an idea for legislation, the governor doesn't have the opportunity to do that. She's not authorized to do that, but she can put policy, particularly policy that might have a financial needs financial support in the budget. Now, of course, those policy initiatives, along with all of the appropriations that she lays out in the executive budget, then goes to the Assembly and Senate for their review. And ultimately, everything gets negotiated before the final state budget is issued. So some Article 7s might be proposed and then appear as proposed in the final budget. Some may be modified in the final budget, and some might be omitted and not included at all in the final budget. And as we move through these next sections, I have incorporated into the slides for you the references within the budget where these policies or bill numbers exist. So you have them for reference, and everyone will be getting copies of the slides and the recording, as I said. So I wanted to start by focusing on some statutes that have sunset provisions, meaning they are set to expire on a 2-year cycle. And every 2 years, the legislature and governor approve the extension of these timeframes or deadlines for 2 more years. And we saw that again for this year. The 3 that impact our community relates to the mandatory arrest law. Now, of course, we know that police must make an arrest when they have reasonable cause to believe that a person has committed a specific crime against a family or household member. So that's the first extended law. The second relates to the use of closed circuit TV testimony for child victims. And these are children who are 14 and younger who are participating in a criminal proceeding. And extension of the statute permitting maximum lengths for criminal orders of protection. So these 3 laws were set to expire in September of this year, and they've now been extended until September 1st of 2025. And those maximum lengths for the orders of protection, just as a reminder, is 8 years for an order of protection that's based on a felony conviction, 5 years for a misdemeanor conviction, and 2 years for offenses and violations. Now, you may have heard that there were some amendments made in 2023's budget to the bail reform and discovery laws that were initially implemented in 2019. I'm not going to cover every aspect of those amendments, but there's one particular provision embedded in those amendments that's very important to us and didn't get a lot of attention in the media coverage. So I wanted to be sure and review this really at the early part of our discussion today. And it relates to the provision of appearance tickets to individuals who are arrested under New York's mandatory arrest law. So as initially enacted in 2019, individuals who are arrested under the mandatory arrest law could be issued an appearance ticket. Now, police had the discretion to physically arrest them. In other words, to bring them to a police station for arraignment. But once police had the authority to issue an appearance ticket, what we were hearing is that most arrests were not involving a physical arrest. The abusers were given an appearance ticket and told to show up to court at a later time. And this posed an increased risk to domestic violence victims because they didn't have the ability to meet with domestic violence advocates or to do a safety plan, get themselves safe before that individual, they never left the area, they returned home or at the DV survivor's place of work or wherever, and it really could increase the risk to that victim. So now this year, in the amendments to the bail reform law, police are now prohibited from issuing appearance tickets to those arrested under New York's mandatory arrest law. So they must be physically arrested and brought to the police station for arraignment. Now, because there are so many scenarios where police can now issue appearance tickets instead of bringing someone to the police station for arraignment, that period of time, that period of physical arrest, I'm hearing is somewhat abbreviated than it used to be because there aren't as many in-person arraignments happening. However, I still think it might be better for domestic violence survivors for those arrested to actually go to a police station for arraignment. It gives them a little bit more time to do that safety planning that we know is so critical for them. There were 2 Article 7 provisions approved in the budget relating to public assistance. One, increased access to education and training for recipients. So for recipients attending post-secondary education for 1 year or longer, they no longer have to perform the 20 hours of work each week. It also permits recipients to go for vocational training. And once they do get a job, it permits a one-time disregard of their earned income for 6 consecutive months to get them back on their feet. The second provision relates to skimming, particularly of public assistance benefits. So skimming is when a bad actor will install a device at a point of sale terminal, like a gas pump, to steal the card data that someone puts into, the little payment slot at the gas pump and drain the recipient's account of benefits. And this is actually on the rise in New York State. From October 22 to March of 23, more than $1 million in cash public benefits was stolen from over 4,000 households. And when you look at SNAP benefits, 6.3 million was stolen in that same time period. So thousands of public assistance recipients are dealing with this kind of fraud. This Article 7 allows DSSs to reimburse victims for this fraud when their public assistance benefits are stolen. And it also requires the DSS to provide the reimbursement within 5 days after verifying the existence of the benefits and that they were stolen. So that's a great one for all recipients of public assistance. A couple of new policies for childcare. One allows the Department of Social Services to increase monthly rental subsidies for recipients in order to get their children discharged from foster care. So this would be if the only factor that's keeping children in foster care is the parent's ability or guardian's ability to pay rent, then this would enable DSS to increase that monthly subsidy from $300 a month to $725 a month. Now, I think we can all probably agree that $300 a month for any recipient of public assistance for rent at this point is probably not sufficient to make up that full payment, that monthly payment. So we're going to be advocating, I think in 2024, you'll hear me talk about this a little bit later, that we'd really like to see this amount of the subsidy increase for everyone. And the second new initiative relates to a presumption of eligibility for individuals who apply for childcare assistance. So this permits the local DSS to presume that individual is eligible for childcare assistance and start paying it out to them immediately. And ultimately, if the DSS denies the application, then it would require DSS to send a written notice to the applicant explaining why they were denied, as well as information about their right to a fair hearing. So now moving on to the courts, there are a couple of Article 7s that I wanted to elevate for you. The first is that the wages, the hourly wages for 18B attorneys, these are the attorneys who are pro bono attorneys ordered by the court to represent a litigant. These wages had not been modified for a long time. They had been set at $75 an hour, which really is not a lot of money for legal work. So it raises these hourly wages to $158 an hour. And one other aspect of this is that it doesn't only relate to the 18B attorneys, but it also relates to any expert witnesses who provide testimony or support litigation. In addition, the Article 7 increases the maximum compensation that can be allotted for any individual case pretty substantially. That's gone up to $10,000 per case. And it also increases the maximum compensation permitted for expert or other service providers to support or provide testimony in court. And that has been increased to $3,000. Now, again, I just wanted to come back to the changes that were made to the 2019 bail reform law, because there was an Article 7 that related to this. And like I said, I don't want to go into too much detail here, but there were a couple of additional changes that were made to how the courts make decisions about pretrial release. The 2019 law required judges to use a least restrictive standard when setting pretrial conditions. The conditions are intended to reasonably assure the defendant's return for future court dates. Now, the 2023 changes eliminated the least restrictive standard and replaced it with language requiring judges to base decisions on an individualized determination that considers the kind and degree of control necessary to reasonably assure the defendant's return to court. Now, you might hear that and say, well, that sounds pretty similar to the reasonable, the least restrictive standard. And that's true, it does. I mean, some are saying this is just semantics and it might not actually change anything. But others are saying this could cause some judges to impose more onerous conditions on defendants, including setting cash bail. So we'll have to see, in time, how the courts implement this change. Another change relates to the factors judges can consider when setting bail. Now, previously, for domestic violence cases, judges could consider the defendant's history of gun use or possession and any previous violation of an order of protection. Now, the judge can consider these factors in all cases where they're considering setting bail, so no longer limited to domestic violence cases. In addition, a new factor has been identified that can be considered for all cases, and that's a consideration of whether the alleged crime caused serious harm to one or more individuals. Now, there's one additional Article 7 that you might be familiar with, which is one that would have crafted a model domestic violence policy for counties, or really an update of earlier model policies that were created by OPDV and domestic violence advocates. This policy didn't make it into the final budget, so it was not approved. The policy was intended to assure the use of best practices that foster survivor-centered, culturally responsive, and trauma-informed responses across all systems. In order to create the policy or update the policy, OPDV would have been tasked with organizing a pretty large task force of state agencies and representatives from domestic violence programs, hospitals and medical providers, mental health and substance use providers, probation, criminal justice agencies, law enforcement, schools, to work through, the existing policy and update it. And OPDV would hold a public hearing and also provide training and TA to any entity, municipality who wanted to implement the policy once it was updated. So that takes us through all of the Article 7s that I hope to review today. I'm going to take a pause, take a drink of water, and Brittany, maybe you can let me know if there's anything in the chat that I should be reviewing.
Hey, Joan, nothing in the chat so far, but I do want to take this opportunity to let folks know if you do have questions at any time, feel free to either drop them in the chat or drop them in the Q&A feature, and we'll get to those questions as soon as we can.
Great, thank you. So now we're going to talk a bit about some of the bills that moved through, that got approved by both the Assembly and Senate. Before we do that, I just wanted to give you some context for this year's legislative session. There were just shy of 900 bills that passed both houses this year, and that's about 100 fewer than last year. So on hearing that, you might think, oh, it wasn't a very successful session. In fact, about 900 bills is what the chambers historically tend to approve together. Last year was a little bit of an outlier. They went, a little crazy with the number of bills that they passed together. So this is a little more where we see the average sitting, about 900 bills. Now, the governor acted on about 30% of them at this point, so there are many more that still need to be acted upon. And the governor has until the end of the year to sign or veto bills. If she takes no action on a particular bill by December 31st, then it's essentially vetoed, and that's referred to as a pocket veto. So the first laws I wanted to talk about are 4 laws that were signed in 2023 that actually amend laws initially passed last year. in 2022. So for each law I discuss, I first will describe the 2022 law and then let you know how the 2023 law amends it. So I hope this doesn't get confusing. But first, you might remember that last year, there was a new crime established for the unlawful dissemination of a personal image. And this year, a law was approved and signed that makes sure that the crime applies to images that are posted on social media and those showing some degree of injury to a person if the individual who's posting the image participated in the underlying crime. The 2023 law also clarified that this crime of unlawful dissemination does not apply to images that are of public interest, are newsworthy, or of artistic value. We were a bit disturbed to see this last piece approved by the legislature and governor. We think that it could result in many images being carved out of this crime of unlawful dissemination because, determining what's of public interest or what's newsworthy is quite subjective. So we'll have to keep our eyes on this and see if we want to work on amendments in the future. The second law addresses last year's law to create a statewide electronic tracking system for rape kit evidence that is collected to support a criminal investigation. So you might recall, separate from this, the state has established a storage facility for materials collected from victims during rape kit exams when a criminal proceeding has not been initiated. The 2023 law clarifies that the tracking system required by the 2022 law is for the material that's been submitted to law enforcement to support criminal proceedings. So not the material that is stored before a criminal proceeding has been initiated. Obviously, this is very confusing, and we want to ensure that victims understand where their materials are stored, whether it's stored at this facility in Washington County because a criminal investigation has not been initiated, or if it's been surrendered to law enforcement because it's been because a criminal proceeding has been initiated and is being tracked under this new electronic tracking system. So NYSCADV is working with DCJS and OVS to ensure there's clarity to survivors on where their materials are. Now, you also might recall a law from 2022 which permitted domestic violence victims to self-attest to their status to break bundled or family plan telecom contracts. So that would be television, phone, and utility contracts. The 2023 law changed the effectiveness date of last year's law to June of this year. So changes could be made to further protect domestic violence survivors against abusers seeking to obtain the accommodation for themselves. Unfortunately, the bill to incorporate these protections did not pass. So this is something we're going to be working on quite a bit in 2024. And finally, in 2022, there was a groundbreaking law to mandate domestic violence and child abuse training for forensic child custody evaluators. A new law in 2023 amends last year's law to permit children who are living out of state more than 100 miles from the New York State border to be interviewed remotely. And it also clarifies that OPDV, along with NYSCADV, will be mutually responsible for the development and the provision of that training. And the effective date of the training is now December 23rd of this year. We talked about some of the 2-year extenders that extended certain sunset provisions contained in the state budget. There was another 2-year extender that has been signed into law because it initiated as legislation in the Assembly and Senate and then was later signed by the governor. So same result, just slightly different process. And this extends for 2 years the income and resources exemptions for public assistance applicants. So this permits applicants to retain a certain level of liquid resources, their home, a car, a burial plot, any money set aside for funeral arrangements before, so that those resources are exempt from the calculations to consider eligibility for receiving public assistance. So now these exemptions are in place until August of 2025. Now, this isn't really a law because it doesn't get signed by Governor Hochul, but I did want to include in our review the Equality Amendment because it was approved by both chambers of the legislature. And you might recall it was also approved by last year's legislature. So now the Equality Amendment is moving on to a ballot initiative in 2024. So what does the amendment do? Well, currently, our state constitution prohibits discrimination based on a person's race or religion. It's limited to that. This amendment would add several classifications of to prohibit discrimination. So it would add ethnicity, national origin, age, disability, and sex. And it includes sexual orientation, gender identity, gender expression, pregnancy, and pregnancy outcomes. It also protects against any government actions that would curtail a person's reproductive autonomy or their access to reproductive health care. So we think this is a very important piece of legislation. We're pleased that both the 2022 and 2023 legislatures approved the amendment, and we're hopeful that registered voters will approve it in 2024. So several new laws relating to enhancing protections for reproductive health and for those who provide reproductive health services. I'm not going to go into much detail. I did leave you the chapter numbers of these if you're interested. And I should also mention, if you don't have access to finding bill text, if you don't know how to do that, if you're interested in getting a bill memo, just reach out to us. Our emails, Brittany's and my emails, are on the final slide. We'd be happy to provide you with bill text or bill memo, whatever you might be looking for, if you wanted more information about any of the policies or bills that we're discussing in today's webinar. So the first enhances legal protections for abortion service providers, and it ensures that they cannot be arrested and extradited to other states for performing legal abortion in New York State. It also prohibits cooperation with out-of-state investigations related to the performance or aiding in performance of abortion performed in New York State. There's a new law that allows hormonal contraception to be available over the counter at pharmacies. And this essentially authorizes licensed doctors and nurse practitioners to prescribe essentially generic orders to pharmacists to dispense the drugs. And then pharmacists can do so if they provide a patient with a self-screening risk assessment and a fact sheet. There's a new law that ensures access to medication abortion drugs at SUNY and CUNY campuses. They can either employ authorized prescribers or they can provide referrals to authorized prescribers. And finally, there's a new law that protects healthcare providers who offer reproductive health services via telehealth. And this also ensures that these providers won't face any professional disciplinary action for doing so. And a few new laws relating to the LGBTQ+ community I wanted to bring to your attention. 2 new laws that require the use of gender-neutral terms in state law and on state websites. So this would be prohibiting terms such as husband, wife, fireman, policeman, but it doesn't apply on websites that address a gender-specific matter like pregnancy. Chapter 143 is entitled the New York State Safe Haven for Trans Youth and Families Act, and this prohibits a court from considering a finding of abuse based on a parent allowing a child to seek or receive gender-affirming care. And the new law also prohibits law enforcement cooperation with other states regarding provision of gender-affirming care in New York State, and also prohibits courts from executing subpoenas for out-of-state proceedings. So that's a really great new law. And we think it's certainly moving us more in the direction that we want to see New York State be in. And finally, there's a new law that updates the definition of sexual orientation in the human rights law. It removes an outdated disclaimer connecting homosexuality to illegality. So this was just a very arcane provision that's now been updated in a positive way. So those were the pieces of legislation that have been signed into law, but more pieces of legislation are awaiting the governor's action. So before we move on to these, Brittany, is there anything in the chat I should be addressing?
You're good to move on, Joan.
Okay. All right. So this is a lot. I'm just going to take a little breath before we move on. I know I'm talking a lot and I apologize for that. So I wanted to start with one of NYSCADV's priority bills. We were working in coalition with Common Justice and New Yorkers Against Gun Violence and other organizations and providers to move the Fair Access to Victim Compensation bill forward. We are so pleased that both chambers approved this bill because we know that financial compensation in the aftermath of crime gives victims increased stability by covering costs such as hospital bills, mental health counseling, lock replacement, and installation of security systems, and replacement of personal property. Now, in New York State, currently, to be eligible for such funding, victims have to report their harm to law enforcement within 1 year of the crime occurring. Now, for a variety of reasons, including fear of retaliation or blame, or mistrust in law enforcement or shame, victims may wait to report or choose never to report and miss out on obtaining victim compensation. In fact, a 2015 survey found that of respondents who chose not to contact law enforcement, 70% said they were afraid that doing so would make things worse, be ineffective, or have significant negative consequences for them or their children. And we know that limiting access to victims who are comfortable interacting with law enforcement disenfranchises thousands of crime victims and perpetrates inequality in a system created to help, not harm, these individuals. So what would fair access to victim compensation do? If it's signed into law, it would allow individuals to be eligible for victim comp regardless of whether a suspect has been arrested, charged, or prosecuted. And it would no longer require victims to report crime to police. Now, those victims who want to report their crime certainly can continue to do so, but it's no longer a requirement for eligibility. Instead, individuals can provide a third-party attestation to support their claim. And that attestation would be provided by either a New York City or New York State licensed victim service provider. The bill also expands the time frame for an individual who wants to report to law enforcement from 1 year to a reasonable amount of time. And it expands the time frame for individuals to file claims with the Office of Victim Services from 1 year to 3 years. So we are really hoping the governor chooses to sign this bill into law. Another bill that we hope the governor signs is one that creates a Hope Card program in New York State. Now, if you haven't heard of Hope Cards, there are a few states that have implemented this program already. These are wallet-sized laminated cards that contain information regarding final orders of protection. So currently, when a court issues an order of protection to a victim, the victim receives a paper copy of the order and is instructed to carry it with them at all times. Now, these orders contain all the relevant information needed by victims to ensure the order is fully enforced. So this can be multiple pieces of paper, which is cumbersome to carry around. They get torn, they're folded, they rip, they don't fit in a small purse. Now, victims can request new copies if their paper copy gets damaged, but we know that takes time. And we're also hearing some disturbing news that victims are waiting months to receive copies of their initial order of protection, or they're being required to go to a records room to get the copy. Hope Cards will contain all of the information that's needed to show they have an active order, that an active order has been issued. So the bill directs the Office of Court Administration to develop the program and make these Hope Cards available to victims who request them. And the cards would be free of charge, so no cost, and a victim can request any number of cards. There's no limit. So these cards would have the same effect and validity of a paper order of protection issued by the courts. So I just see a question in the chat. What about the initial orders? It can take years to resolve cases for final orders. Thank you for that question. There's a lot of reasons for only applying the Hope Cards to final orders, recognizing that the time frame for moving from a temporary order to a final order could take many months, if not years. But it would be impossible for OCA to be able to issue cards for temporary orders that change frequently, because in some cases, in some litigations, parties are getting temporary orders changed. Temporary orders are issued multiple times. And we've seen from some of the other states that there's a lot of confusion that results when the cards also apply to temporary orders, that it's a much cleaner program if it only applies to final orders of protection. So we can talk a little bit more about why this would only apply to final orders of protection, but that I think gives some idea for why it only does apply to final.
Joan, we have another question. What types of order of protections qualify for Hope Cards? Does it have to be from criminal court, or family court orders also eligible?
Well, Brittany, you might be the best person to answer that. I think it applies to both. Is that correct?
That is, yes.
Okay, thank you. I wouldn't want to give anyone wrong information. And Brittany really was our lead on this piece of legislation. So thank you, Brittany, for piping in on that. So now moving to the Clean Slate Act, you might have seen some media coverage that this bill was signed in the final, not signed, was approved by both chambers in the final days of session. The Clean Slate Act would automatically seal criminal convictions after certain amounts of time. So 3 years for a misdemeanor conviction and 8 years for a felony conviction. So let me unpack this for a little bit. Automatically, that means that the defendant does not have to ask anyone for their records to be sealed. DCJS and docs would provide data to the Office of Court Administration on a regular basis for the sealing to happen. Sealing. Some states that have implemented bills similar to the Clean Slate Act actually require expungement of the conviction information and all of the files related to that conviction. Expungement means the materials are destroyed. New York State's bill does not call for expungement, it calls for sealing. So that means the public at large will not have access to the records, but certain entities will. And we'll talk about that on the next slide. Now, for the records, the convictions to be automatically sealed, there are certain conditions for the defendant. They must have completed their sentence, including parole or probation, and they can't have committed a subsequent crime within the 3 years or 8 years following completion of the sentence. So the clock doesn't start ticking on the period of time for sealing until the individual has completed their sentence, parole, or probation. Now, anyone who's convicted of a sexual offense cannot be eligible for sealing of records. And the bill specifically states that sealing of records would not affect or invalidate any active orders of protection. So this is important because, as mentioned earlier, some orders of protection go as long as 5 or 10 years. But yet, particularly for misdemeanors, and we know most domestic violence crimes are prosecuted as misdemeanors, misdemeanor convictions can be sealed after 3 years. So it is possible that an individual can have an active order of protection based on an underlying misdemeanor crime where that misdemeanor crime has been sealed. That's difficult, and we're going to be watching implementation of that very closely because we think law enforcement is going to be confused by that. And we also think courts might stop issuing 5-year orders of protection based on an underlying misdemeanor crime. So that's a cause of concern for us. Another provision in the Clean Slate Act creates a cause of action for damages against anyone who discloses information about sealed convictions without the consent of the defendant. Now, I mentioned that there are some entities who can request access to sealed records. And this is not an exhaustive list, but these are the entities that I think are most important to our community. So a defendant and counsel will always have access to their sealed records. And any court, defense counsel, or prosecutor for a pending criminal proceeding can also access the records. Now, defendants who are in criminal cases where the sealed records of another individual are integral to their defense can seek access, along with qualified agencies. And these are agencies defined in statute that include law enforcement, probation, sheriffs, district attorneys, docs, CPS, and others. Now, when this bill was being negotiated, NYSCADV and others worked really hard to ensure that civil courts, particularly supreme and family courts, have access to litigants' sealed records. That was not in one of the initial drafts of the bill. And we successfully got that incorporated in. So both the court and parties in civil proceedings will have access to a defendant or litigant's sealed records if they become a witness or a party to that case, or if the defendant becomes a witness in a criminal case. And access also extends to individuals who are trying to avail themselves of a public program or benefit, such as an immigration benefit, like obtaining a U visa. So that was also a very important provision to be included in the bill. Now, entities who are performing fingerprint-based criminal history checks and those who employ police officers or issue gun licenses can also have access. And essentially, any of these entities who are seeking access would complete a form that DCJS is going to develop, and then DCJS would be responsible for providing the information sought. Now, NYSCADV has asked Governor Hochul to sign this bill because we believe it will permit thousands of New Yorkers to find employment, housing, and other supports to ensure their successful re-entry into local communities. And that includes victims of domestic violence and sex trafficking and sexual assault who are convicted for their acts taken to stay alive. However, we have recommended to the governor that some additional chapter amendments be made, such as prohibiting sealing if there's a valid criminal or civil order of protection identifying the defendant as an offender or respondent. So that would address the confusion that I discussed earlier with respect to different timeframes for orders of protection and the sealing of a misdemeanor. In addition, we want to ensure law enforcement has immediate access to the sealed records like they do for orders of protection through the registry. And we think there should be a time frame added for DCJS to provide information from the sealed records to entities that request them. So in other words, if there's a party in a family court proceeding who requests another party's sealed records, we don't want that request to delay that court proceeding. So I think I see at least a couple of questions in the chat about this. Let's see. Wow, a lot of questions. Okay, so does this bill seal records of people with convictions for child abuse or manslaughter? Yes, it would. It would. Felonies, the most serious, would be 8 years of conviction, and there is no prohibition for those that are convicted of child abuse. Would this impact individuals from being charged with aggravated family offense if their prior family offense is now sealed? Caitlin, I think that's a very good question, and I don't have the answer to that. So I think it's definitely possible. We're going to see how the courts and law enforcement and prosecutors respond. I will say that prosecutors will always have access to an individual's sealed records. So they will have access. What about the information of issuance of the temporary orders or orders that have expired on the DV registry that the courts are required to review? This impacts information on history of parties. Margaret, that's exactly correct. And that's a concern that we've elevated to Governor Hochul. And I would suggest that if others have concerns about this aspect of the Clean Slate Act, now is the time to mobilize and maybe, send an email or a letter to Governor Hochul. We can certainly provide that information to you on how to do that, to note your concern. We think it's very important that advocates and those in our community who are concerned about this elevate those concerns to the governor's office now. And what if someone is charged with a new crime but not convicted of a new crime, would this still prevent automatic sealing? If I am understanding Judith's question correctly, I do believe I'm going to switch back here to my slide. So they cannot commit a subsequent crime within the period of time that they've completed their sentence and the ticking clock of 3 years or 8 years. So they do not have to be convicted of the subsequent crime. It's commission of a subsequent crime. I hope that answers the question.
And we have one more question around who would have access to the information still. Would law enforcement advocacy programs still be granted access by proxy? Assuming that this would be an advocacy program located within a law enforcement agency.
I'm not sure I know the answer to that. I was just pausing to think about that and think about how the bill language reads. If they are enumerated within the definition of a qualified agency, because that is a statutory definition, then the answer would be yes. I just don't know if those organizations are spelled out as a qualified agency, but that is something we can look into. So Brittany, if you would make note of that, we can look into that and get a response back. So Eileen is asking if there are ways we can support pending bills. Since these bills have passed both the Assembly and Senate, all of the bills I'm talking about in this section, if anyone is interested in doing advocacy on these bills, whether you support, oppose, have questions, I would say the best entity to contact would be the governor's office, because at some point these bills are going to be delivered to her office for her action. And that will mean either signing it into law or vetoing the bill. So we can provide more information on how to do that. Brittany, maybe you can put that in the chat, or we can circulate a how-to guide with resources when we circulate the slides and recording. So I'd like to move on because I see we're at 11:30 and there's still some more information I'd like to focus on. So one of the bills that passed both chambers, again, awaiting the governor's action, is a bill that would require OPDV, the State Office for the Prevention of Domestic Violence, to create informational materials on economic abuse for domestic violence victims. So these materials would describe economic abuse, including information on coerced debt, include information about resources for victims, and then this information would be made available at domestic violence shelters, local departments of social services, police departments, and child care facilities. Another bill would require family courts, at the request of a biological parent, to order post-termination visitation between the child and that parent if the parent's parental rights have been terminated. So this order of post-termination visitation is subject to the best interests of a child. And if any of the parties to this family court proceeding objects to the post-termination visitation, then the court is required to hold a hearing to determine if the visitation is in the child's best interest. And the parent who is applying to get post-termination visitation would be responsible for the burden of proof, proving that such visitation is in the child's best interest. Now, there is provisions in the bill to ensure that children who are aged 14 or older who don't consent to the post-termination visitation, then visitation would not be permitted. And it also would not be permitted if a parent severely or repeatedly abused a child. Now, I think with this, later provision about abuse, Of course, this is somewhat subjective. I'm not sure any visitation should happen if a parent abused a child, period. I don't know why we need severely or repeatedly abused a child. But again, this is something that we could, as a community, communicate with the governor about if we were hoping for a chapter amendment with respect to that provision or any aspect of the bill. There's a bill that would establish a task force on missing women and girls who are Black, Indigenous, and people of color. Now, we know that there are thousands of missing Black women and girls, as well as missing Native American women and girls across the country. And these are individuals who have been abducted, sex trafficking victims, runaways, and they don't receive the same amount of attention for Caucasian women who go missing. And there are barriers for these families to report a missing loved one. So this task force would be made up of state agencies, including OCFS and DCJS, and also including directly impacted individuals. And the objective would be to identify policy changes to address the lack of care and concern for these missing individuals. It also would identify policies to ensure first responders are culturally competent, would recommend programming to advance safety, create a statewide awareness campaign, and also develop a strategy to collect data about these individuals and oral histories. Now, some bills passed both chambers affecting courts. The first involves individuals who believe they've been wrongfully convicted. So this would extend due process protections to applicants for post-conviction relief. And this follows a 2018 Court of Appeals ruling that people who pleaded guilty couldn't challenge their convictions on grounds of actual innocence unless they had DNA evidence supporting their claim. So this bill would enable those individuals a right, it would provide them with a right to access their complete discovery and retest physical evidence and get the opportunity for meaningful review of their case. This second bill follows changes made more than 20 years ago by Congress to federal immigration law, where legal immigrants and residents may be subject to automatic removal from the US if they plead guilty to minor offenses such as violations. So this bill would require notice to those defendants that they risk deportation or denial of citizenship if they're not a citizen, if they pleaded guilty to a misdemeanor or a violation. And there's also a bill that relates to, that would modify the current definition of rape, which is extremely limited in that it applies to only penetration of the vagina with a penis. So men and trans women have categorically been excluded from ever being victims of rape. This bill would remove the penetration requirement from the rape statutes and redefine rape to include oral and anus sexual contact, recognizing that other forms of forced penetration or sexual contact can be equally painful and traumatic. There's a bill that will be in front of the governor with respect to permitting legal affirmations under penalty of perjury, rather than a notarized affidavit for all litigants and non-party witnesses in civil courts. So this, we know, obtaining a notarized document is quite burdensome for individuals. And the federal law already removed similar requirements decades ago. And in New York State, attorneys, physicians, and dentists are already exempt from having to notarize affidavits. So this would now permit any individual, any litigant, to provide a legal affirmation under penalty of perjury rather than the notarized affidavit. And we've all heard about the significant backlogs in various courts across the state. There is a bill that passed both chambers to relieve some of that backlog by increasing the number of judges in certain courts. I've listed them out there for you. Increases to Supreme Court, more judges in New York City's family, criminal, and civil court, and one additional judge in various family courts around the state. And now I'm going to run through some other bills pretty quickly because I do want to leave enough time for questions. And these are just sort of random. There is no category assigned to these, but I did just want to review them before we turn to questions. So there is a bill that passed, and all of these passed both chambers. So there is a bill that creates a licensing requirement for athletic trainers. And in the various provisions of this bill, it also designates athletic trainers as mandated reporters. There's a bill that would prohibit sexual harassment victims from paying damages for violating non-disclosure agreements. So these are the agreements that individuals who are victims of sexual harassment are really coerced into signing in order to receive compensation for the harm that they experienced. And frequently, these require victims to pay liquidated damages if they violate the agreement. So years after signing the agreement, if that individual victim wants to share their experiences of harassment and discrimination, and they do so, then they can be financially liable. This would prevent that from happening. And it would also prohibit these agreements from requiring victims to sign a statement that they were not subject to discrimination or retaliation. One of the bills approved by the chambers would not apply fees to any individual who is applying for an extreme risk protection order. So those fees usually run about $200. So that individual would not have to pay. Essentially, it's the index number fee, and they wouldn't have to pay that. And there's a bill that would provide notice to individuals who are released from jails with respect to their voting rights. There, I think, is some confusion about the rights of individuals who have been incarcerated with respect to voting. And anyone who is not incarcerated or on parole for a felony conviction retains the right to vote. So that's pretty limited. Anyone arrested or detained in jails pre-trial can vote. People convicted of a misdemeanor, on probation, or those who completed their supervision can vote. Even those convicted of felonies who have completed parole supervision are eligible to vote. So this notice would inform individuals about their rights with respect to voting, let them know about the importance of voting, and provide resources on how to register to vote. There's a bill that would ensure consideration of accessibility to reproductive health services by hospitals who are seeking to close or merge. There's a number of bills. I only provided the A versions there but they all have companion bills in the Senate that would require posting of information about human trafficking in lactation rooms around the state. So these would be at airports, truck stops, transit, MTA facilities, transit facilities, lactation rooms in those types of buildings. There's a bill to extend the Human Trafficking Task Force for 4 more years. There's a bill to investigate the connection between social media and human trafficking, because we know that social media is the most common tool used by traffickers to lure victims. In 2021, there was an estimated 25 million people who were trafficked. So understanding the connection between social media and trafficking is very important so that trafficking can be prevented proactively. And there's also a very important bill that passed both chambers that would create the New York State Community Commission on Reparations Remedies. And this would examine the institution of slavery, how it affects present-day society, and whether compensation should be provided to those impacted. This bill has a really extensive summary in the bill memo that if anyone was interested, it's really worth a read. I learned a lot by reading that bill memo, so I highly recommend it. So those are the bills that I wanted to review that have not yet been signed into law or vetoed, that will go to the governor sometime between now and the end of the year for her action. So before we do a look ahead to 2024, Brittany, is there anything in the chat I should be addressing?
So we had one question come in, and it was around the visitation after termination of parental rights. Would this be retroactive for bio parents who have already had their rights terminated?
I believe it's at the individual who had their rights terminated can request this of the courts at any time, I believe. That is something I can double check, but I think it's at any time.
Okay, that's it.
Great. So just a couple of slides on looking forward to 2024. It probably doesn't surprise you that NYSCADV is identifying funding for domestic violence services as our top priority. This includes the VOCA issue, but really taking a look at how New York State funds all domestic violence services to ensure stabilized funding, right? And we also want to ensure that domestic violence advocates and staff at domestic violence agencies are not ignored with respect to cost of living adjustments, bonuses, and increased wages. And a certain piece of this also relates to how New York State is contracting with domestic violence service providers and really all nonprofits. We know the delays. It's unusual, frankly, to have an executed contract with New York State at the start of a contract, and that's frankly shameful. So there are multiple provisions in statute with respect to how New York State should be contracting with nonprofits who are doing the work of the state that we don't think the state is following. And we're going to be really delving into that in 2024, as well as looking at what levels the state has for public benefits. We'd like to see those public benefits increased, particularly that housing subsidy that we reviewed earlier. Now, in terms of legislation, I don't really have time to go into all of these bills, but there's some very exciting legislation that's already been proposed. There's a relatively new bill that would address coerced debt. It would require creditors to cease collection activities and stop reporting the debt to credit reporting agencies if, after an investigation is performed, they find that the debt has been coerced. We've been advocating for a bill to make those who call the central registry to report a CPS allegation, to make a report of child abuse, is no longer anonymous. We would like to see it remain confidential by use of a identification number, but that it would no longer be anonymous. And we think that would significantly cut down on baseless claims. We have been advocating for a bill that would reimburse domestic violence programs the same for housing a single individual in a room intended for double occupancy that they would get if there are two individuals in that room. We think there's an inequity here where single adults arriving to shelter or trying to find shelter may not find shelter as readily as an adult with children, because when a DV program houses a single individual in a room with multiple beds, they are unable to receive reimbursement for those other beds. We'd like to jumpstart discussions on the Comprehensive Sex Education in Schools bill. This didn't get a lot of attention in 2023, and we would like to elevate it. We still think it's very important to accomplish. And there's a bill that would increase shelter allowances, again, pertaining to our discussions earlier, at 100% fair market rent. So this would set shelter allowances equal to the actual rent obligation of recipients up to 100% of HUD's fair market rent for the corresponding unit size in the district where the recipient resides. And as I mentioned earlier, we want to ensure that in 2024, the bill that enhances protections for domestic violence services who are seeking to self-attest to their status as a victim to break telecom contracts aren't placed in a negative situation with respect to their financial liability if an abuser seeks to obtain that accommodation before them. So we want to ensure that this bill moves through both chambers in 2024. And we also will be continuing to focus on the package of bills developed to improve family court outcomes for domestic violence survivors. And at the top of the list is Kira's Law, which prioritizes the safety and well-being of children during child custody and visitation proceedings, and also ensures a significant amount of training for judges in domestic violence and child abuse. And I don't have time to review all of the other bills, but there is a supervised visitation bill. There's the bill to ensure access to child custody evaluator reports. There are bills to modify the use of forensic evaluators in family court, either placing a moratorium on their use or even prohibiting them entirely. And also just ensuring accountability for forensic evaluators, ensuring judicial accountability, and making sure that, not only judges, but also court-appointed attorneys and other court personnel are trained in trauma-informed care when they're dealing with domestic violence survivors. So that brings us to a close for what I was hoping to cover today. That's a lot. I am going to take another deep breath and pause to see if we have any additional questions, anything to address in the chat.
I'm not seeing any questions in the chat. If folks do have a question, please feel free to either put it in the chat now or in the Q&A. We're more than happy to answer those, but we also understand that a lot of content was covered today, so folks may be just kind of taking it in right now. Joan and I are always available to answer questions after the fact, so if something comes up, I'll drop our contact information in the chat again as well.
And as we're waiting for a few moments to see if there are some questions, I did just want to put our save the dates to those interested. February 28th will be our Budget Advocacy Day. And in light of what we're contending with respect to VOCA and other funding issues, I think that, I encourage all of you to have that date in your calendar. Let's put it that way, as well as our annual Legislative Day of Action, which will be April 30th, 2024, again in the well of the Capitol. And just so you are aware, we do have our emails here as the final slide. So, certainly feel free to reach out to us. As I said, you will be getting these slides as well as the recording. So anything more in the chat? I don't think so. Well, let me say thank you to everyone who's joined us. It's been my pleasure. to be with you today. And please, as Brittany said, feel free to reach out if you do have any questions. We're always happy to provide copies of bills or more information. This was a lot to cover, and I wouldn't be surprised if upon your thinking about it, your internal reflection, you might have additional questions for us. So please don't hesitate to reach out. Thank you.